Hi, my name is Tara Welrod, and this is my Module 13 presentation on tort liability. Tort law is actually when a person or persons are legally responsible for the consequences of their own behavior when such behaviors result in injury to others. And there are two types of torts. There's intentional torts, which are deliberate acts, and examples of that would include assault, battery, false imprisonment, mental distress. And then there's also unintentional torts, which is when someone fails to carry out a reasonable degree of care or someone who acts negligently. And examples of that are standard of care, breach of duty, legal cause, and injury. The first case that I am going to talk about is a case of Melson versus Botas. It happened in Michigan in 2016, and the claim was of IIED, that there was an intentional infliction of emotional distress. In this specific case, it was found in a classroom that a student who was having trouble finishing an assignment, the teacher was frustrated and commented to the student, "Why don't you just kill yourself?" Given her position and level of authority as the student teacher and that this happened in a classroom setting, the court did hold that reasonable minds would conclude that her remark were extreme and outrageous and did find her negligent in this case. Reactive measures are when, in this case, things happen in classrooms. They do. But teachers have to remain calm and call for help if they don't know how to help or handle a student. I know at my school we have walkie-talkies, and you can call for help whenever you're frustrated or need extra help with a student. Proactive measures, teachers must use behavioral management systems that promote positive praise instead of insults or shaming students. It helps if they have a classroom management toolbox. Some schools have classroom management systems throughout the entire school that all teachers follow the exact same plan, and that can be very safe because everyone's on the same page doing the same thing. Ethically, in this case, very unprofessional conduct, at the least. She did end up being terminated due to the extreme nature of the comment, in this case, which ethically she should for being so unprofessional. The next case I looked at was Mason versus Metropolitan Government of Nashville and Davidson County Schools, and this occurred in Tennessee in 2006. And this was actually a bus incident, so I thought it was an interesting case. The student brought negligent action against the school district after the student was attacked on a bus by another student. Now, the courts do not impose upon teachers the duty to anticipate or foresee all the hundreds of unexpected things that students do or occur within a public school each day. So, because the attacker had not been known to ever have brought a weapon to school or really caused a lot of trouble at school, the court found this was not a foreseeable act and actually found for the school district in this case. Reactive measures, in order to keep students safe on buses, the bus should have expectations, just like classrooms do, and student management systems. And bus drivers can always stop the bus. They can order the students to stop fighting, and they can even call dispatch for help with student safety. Proactive measures, bus drivers should be trained, just like teachers, on student safety, but also they need to be trained on student management because they have so many kids in a confined space and learning how to manage that. So professional development along with understanding how to manage students. Ethically, when arguments do escalate into fights, it's really important that all school personnel know basic techniques for dealing with physical aggression. We don't want students getting hurt, but we also don't want drivers or teachers getting hurt either. The next case I looked at was Gosh versus Sergeant Bluff Luton Community School District. This happened in Iowa in 2014, and this happened with a special education teacher was accused of dragging a first grade boy by the ankles across, it was a carpeted floor. The boy was diagnosed with ADHD and autism, and at the time was lashing out. The judge did find that the teacher did what was necessary and reasonable for the safety of the child and all others involved, the other children in the room. So the reactive measures that in order to keep children safe, teachers really should remove the other students, give choices to the students still in the room, remain calm with the student, and remove any items that could cause the student to hurt themselves or someone else. Proactive measures, students with disabilities and IEPs usually have plans that should be used. Also, we use ABC data, antecedent behavior and consequence of the behavior, in order to make plans for students that do escalate, and that way everyone is on the same page and knows what to do, so that students don't reach this kind of level of being so upset. Teachers can also be proactive in helping students calm down before escalation even begins, and you can use CPI techniques to help train teachers to know what to do to keep students safe. I know our resource teachers, counselors, paras are all trained with CPI techniques. Ethically, physical force cannot be used in most school districts. Students can be restrained, but only by trained personnel. But that is also after all verbal de-escalation techniques are exhausted. Then restraint can happen, but only if it is truly an incident where the child is going to hurt themselves or someone else. The third case I looked at was Kaufman versus Garnett. This happened in Virginia in 2003. This actually happened with a student and a football coach. So the Virginia Supreme Court considered whether an injured football player had alleged sufficient facts to establish a claim of gross negligence. This also looked at assault and battery against his coach. So Kaufman was a student, and he was 13 years old. He weighed about 144 pounds and was actually playing football for the first season that he could actually play football. The coach, who weighed around 266 pounds, was unhappy with how he performed in a game and actually wanted to talk to him after the game and show him a proper tackling technique. Now, he actually tackled the student in order to demonstrate the technique, and in doing that, the coach broke Kaufman's humerus bone. Now, in this case, the judge found no evidence that the tackle itself violated any rule or usage of the sport of football. Because the student could have been tackled by a larger student in a game, and the same thing could have happened. So this was an interesting case. It actually found for the football coach, not for the student. Reactive measures and correcting behavior, or in this case, technique. He could have used student-to-student contact, or even shown videotape in order to demonstrate the technique, not done it himself. Proactive measures, great coaches and great teachers, they motivate players, they don't lose their cool, they keep perspective, and they help athletes believe in themselves. So I think teaching coaches and teachers to be not only positive, but understand the impact they have on students with their words and actions should be taught early and often in their career. Ethically, physical force, again, not used in most districts. However, in this case, because the parents signed a waiver that football does involve physicality, even though the parents assumed that physicality would be kid to kid, not adult to child, because they signed that waiver was actually why the football coach wanted this, because it was football and it did involve physicality. If this had happened in a classroom, it would have been a completely different thing, or even in PE class. But because of the football waiver, the coach actually won in this case. The next one is a counseling tort case, which interested me because I'm a counselor. So it was Brown versus Compton Unified School District. This happened in California in 1998. And according to the complaint, Brown, who was a student, enrolled as a senior, and he did it with the express purpose of taking required classes to satisfy his NCAA eligibility requirements. And in doing that, he also agreed that he would participate in their high school basketball program his senior year. His counselor was Mrs. Bonner, and she actually advised him to enroll in a particular science course, and then what happened was that course did not meet NCAA requirements. So Brown lost his scholarship and was not able to get into the school that he wanted to for basketball, and that became obviously a problem, so he sued the school district. He sued for negligence, duty of care, and breach of contract, since he said the school knew he had this express purpose of meeting those requirements. Now, the plaintiff, which is actually Brown, filed a governmental tort claim against the defendants, alleging that they failed to properly counsel him, and because of that, the school was found to be immune in this case. So it also talked about the number of student to counselor ratio was extremely high, so that they did not meet the requirement was not all put on the counselor. So reactive measures, could the student have maybe taken a different course over the summer online or even through a junior college in order to complete that requirement? Proactive measures, the schools have to be aware, and we do as counselors have to keep up with NCAA requirements for graduation. It's really important that you meet with especially college-bound students, but really all students their junior year, to make sure that they are on track to meeting their goals and going post-graduation to wherever they want to do, and that they're ready and prepared. Ethically, I found it interesting. NCAA sets these standards because their belief is that they have an ethical responsibility to address academic or admission, what they call mismatches, that result when a Division I athlete isn't able to keep up with the college classwork or coursework and complete meaningful degrees. So that is why they set these requirements, so that students don't get into situations like that. So ethically, that was important because not sure if this class was too low. It didn't meet the science standard that the NCAA required. So those are the 5 cases I looked at. Really interesting tort cases. And thank you so much.